real welcomes to my fellow conference chairs and to the dean, but I want to say a few words and welcome our new dean. We call him our new dean for about a year. He's been here since August, and we're very fortunate to have him on board. He was previously with the University of Connecticut for 23 years. He started as a faculty member, and then he rose all the way up to dean at Connecticut. So he's had plenty of dean experience, which we all know we can use in these times that are a little bit challenging for law school, so we're lucky to have him. He teaches constitutional law, property law, and jurisprudence. His undergraduate degree is from Princeton, and his law degree is from that place in Cambridge, across the pond, Harvard. His work has been published in numerous law reviews, and he has written a best-selling book, which many of you may have used. It's called Getting to Maybe, How to Excel on Law School Exams. So good for him. In addition to his teaching career, he served as a law clerk and worked at the Travelers Group for a number of years. We're very fortunate to have him as our dean, and I'd like you all to welcome him.
Well, thank you very much, Miel. I'm absolutely delighted to be here. You know, anyone who's ever served on a faculty would say I descend to the level of dean. The other way around. But this is a terrific event, and I'm absolutely thrilled to be here. As I told the crowd last night, I've been dealing with women lawyers literally since the day that I was born. My mom graduated law school in 1952 and served 25 years as the general counsel for the Planned Parenthood Federation of America. So I feel right at home here in this school. I want to pay a special tribute to Professor Emeritus Judy Brown. Can you stand up? This conference came about as a result of her inspired leadership in the 5th year, and I hope someday to be back for the 50th year. Do with that. So along with the hard work of the steering group and the alumni office, including our own heroine, the steering group members who are here include Navjeet Bal, Kelly Bonavie, Professor Brown, Vanessa Candela, Kelly Douglas, Kathy Morris, Gina Bellini, who I'm told was recently selected by UCLA as one of 50 women to participate in a global initiative as a result of an award she received with the bank. She was nominated by Northeastern, we were proud of her. Cindy Reed and Rachel Rollins. Many of these women were past conference chairs, and all of them were responsible for the kind of dynamic programming that we're going to have here today. Women in the law is a great tradition at Northeastern. The first woman Chief Justice of the Alaska Supreme Court, now serving as a Northeastern graduate. We have a MacArthur Genius Award winner, Nancy Connolly from Northeastern. The new governor of New Hampshire is a Northeastern graduate, Maggie Bassett. She'll be the commencement speaker in just a few short weeks. And of course, our graduates have been deeply involved in arguing the precedent-setting cases related to gay marriage. So we'll hear more about breaking barriers in just a minute. And our conference chairs wanted to take this opportunity also to welcome you. So let me just briefly introduce them. They are Kelly Douglas from the class of '92 and Rachel Rollins from the class of '97. Kelly is the Senior Employment Counsel North America for Derailed Medical Systems, a $3 billion global medical and safety device company located in Andover, Massachusetts. She was previously Vice President and General Counsel of VinFen Corporation, and she was selected an in-house leader of the law in 2009 by Massachusetts Lawyers Weekly and New England In-House Counsel. She was my dinner companion last night, and forever won my heart by telling me that I too, in addition to all the women at the dinner, was a hot ticket. not of course for anything I did, just for who my mom was. And Rachel Rollins is the General Counsel of the Massachusetts Department of Transportation and the MBTA. She's the first female General Counsel in the history of the MBTA, and the first person ever to serve jointly as General Counsel for both of these entities. Associate at Brigham McCutcheon and Safe Shaw, and she is currently the president of the Massachusetts Black Lawyers Association. So please join me in welcoming Kelly and Rachel.
Okay, this part is a tiny bit corny, and we'll miss USA, but we need a moment of public recognition for conference co-chairs this year. It's a ton of work. We do it for a whole year, and I just wanted to say it publicly. Yay.
We'd like to thank the Academy. So 2 minutes. So I'm Kelly. I'm Rachel, right? And I delight in serving as the co-chair of this conference because I've very directly benefited from the words of wisdom I've gotten from the conference. If you look, this is one of my favorite little handouts in the folder. It's terrific. It's a lot of practical tips. So when you leave here, you're invigorated, you're excited, you've met a lot of great women. Post this in your office, in your home, kind of work your way through the little list. In fact, I got an award because of this conference. One of the attendees, one of the panelists suggested a few years ago, go nominate a woman that you really enjoy working with, etc. One of my outside lawyers was here. She nominated me. I got the award. So it's really easy to do. Turns out they're always looking for people to give awards to. So go do that. I've negotiated better salaries, better titles, more responsibility. I could go on in the way that the conference has directly impacted me, and perhaps more importantly, it's really made me focus on the other women whose professional lives I can impact. So I take the extra time to write the email to the partner about the fabulous associate, that she's the reason I'm staying with the firm. It actually has nothing to do with him. And I make a point of putting it in writing and making sure, and that helps her become partner. And then guess what? She's making more money. And then guess what? She brings along other female lawyers. And on and on and on it goes. In nonprofit settings, government settings, no matter who you are, you will walk out of here today, and I guarantee this, and lawyers don't make guarantees, but I will, invigorated and ready for something else, something different, a way to help someone else. You'll be inspired, and I'm delighted to be part of it, so thank you.
Everything Kelly said, I want us to get started, but I will just tell you this morning as I was getting ready, and my 9-year-old was saying, like, what are you doing today? Are you going to work? And I said, no, I'm speaking to a group of great people. And she said, about what? And I said, well, it's women in the law. And she said, just tell them girls rock. All right, we're going to have a great day today. Let's get started. Thank you, guys.
Thank you.
So I think it's safe to say that Northeastern women were leaning in long before that term became so popular. It is now my honor to introduce our keynote speaker for today's conference, Judge Victoria Roberts from the class of 1976. Judge Roberts was born in Detroit in 1951, and she had her undergraduate degree from the University of Michigan and her JD from Northeastern. She began her career as a public service as a research attorney for the Michigan Court of Appeals. She served as assistant U.S. attorney for the Eastern District of Michigan from 1985 to 1988. And she was appointed to the U.S. District Court, Eastern District of Michigan by President Bill Clinton in 1998 with unanimous advice and consent of the Senate. You didn't do anything wrong? In any event, other highlights of Judge Roberts' career included serving as a partner and eventually managing partner of the Detroit law firm of Goodman, Melinda, and Bedrosian from 1988 to 1998. General counsel to Detroit Mayor-elect Dennis Archer's transition team. She teaches classes at the University of Michigan Law School, and she is the 62nd president of the State Bar of Michigan, being the first black female to hold this position in Michigan history. We're very proud to have her with us today. Please join me in welcoming Judge Roberts.
morning again, everyone, and I'm so glad to be here. I just want to thank Neely Marquis in particular because she was the point person in getting me here and did a lot of gentle prodding in order to keep me on schedule here. And I also want to thank the dean. I see a couple of former professors, Judy Brown, Steve Subrin, who are still professors here, and that's such a good thing. And I also just want to recognize some of my study partners, Maria Quiroga and Marta Figueroa, who came all the way from Puerto Rico. And I think I have in the audience also an incoming law clerk, Rebecca Wasserman. Are you here? Rebecca is coming in 2014. And Northeastern just has been so good to me in many, many ways and has supplied me some great law clerks over the years. And there's also another very special person here, Mr. Feaster, and he's part of my remarks, actually, so I'm going to get started. So when I looked at the theme for this conference, Breaking Barriers, Taking Charge, and Activating Your Career, I thought of the number of times over the course of my career when I had broken barriers, but also been broken. When I did take charge successfully, but other times when I tried to do that and it backfired. And the times when my career was activated only to be derailed. My story, like that of so many others in this room, is one of hopes and dreams, some fulfilled, others not, of opportunity and being in the right place at the right time, of mental agility and toughness, and complete despair. It is a story of relationships with both enemies and guardian angels, of being the designer, the engineer, and the implementer. It is a story of both sprints and marathons, going the distance, even if the finish wasn't always pretty. The story of my career can be broken into very distinct parts, as if separate plots in the same movie. If any of you have seen Ryan Gosling's latest film, A Place Beyond the Pines, you know what I am talking about. Yet each part has a common character, that would be me, with decisions and choices and outcomes that affect the next set of decisions and choices and outcomes. So if my life is a movie, I have several vignettes or short scenes that I want to share with you. And my first vignette is called, So You Want to Be a Journalist. I grew up in a very working class home. Neither parent finished high school. My dad was a mechanic at a steel factory. My mother did domestic work until getting a job putting merchandise tags on clothing for a store that would later become Macy's in Detroit. Needless to say then, my parents' friends were much like them. There were no doctors, there were no lawyers. The most exposure that I had to professionals were the teachers that I had. And among them were many nuns. I can remember thinking at some of the daily masses that I attended that I wanted to be a nun. Never a lawyer. And as I grew older and escaped into the world of books, I decided that I wanted to be a writer, a journalist. And that is what I majored in at the University of Michigan, working summers at a small independent paper, covering weddings and showers and teas for the black middle class that I was not a part of, except to come into their gardens and then go home to my own life. In my senior year at the University of Michigan, as I contemplated a job, the head of the journalism department, Dr. Porter, called me in and offered to help. He told me he could probably get me a job with Johnson Publishing Company in Chicago. It was and is the largest publishing house owned by blacks. It publishes Ebony, Jet, and other magazines. As generous as his offer was, Dr. Porter failed to realize that he didn't even consider that I might be ready for prime time, that is, being a journalist at a press owned by whites. This was the fall of 1972, and times were very different. Major breakthroughs for minorities and women had not begun to occur. And Dr. Porter, for all of his goodness, was not to consider opening that door for me. I declined his offer. I wanted to stay in Detroit. That decision certainly limited my options, but I was successful on my own in lining up an interview with one of the two local majority-owned papers. I remember the day as if it were yesterday. I remember walking through the front door, portfolio in hand, excited by the possibility of a dream to come true. That excitement quickly changed to disappointment and sadness. The editor looked over my work. He had already seen my resume and other writing samples. He leafed through it and said, "You're a very good writer, and you've got a great portfolio, but I just hired a black reporter." He said this very proudly, the obligation fulfilled, and now back to the business of discriminating. As hard a hit as affirmative action has taken, many who did not grow up in the era when doors were slammed shut or never opened in the first place fail to appreciate that affirmative action and lawsuits over discrimination were a direct result of quotas of one or quotas of none, and people being moved out or shuffled out because of race and gender. The door for me at that newspaper closed rapidly behind its quota of one policy, and not to reopen for other minority journalists for a long time. I was devastated. I left the building, got into the car of my then boyfriend who would become my husband. He was a first-year student at Wayne Law School in Detroit, and he had driven me to the interview. I remember crying and not being able to stop crying. Finally, when I stopped crying, he said, "You should go to law school to fight this kind of injustice." And that was really the first thought, that I had to go to law school, and I did. So, this second vignette I called Knocking on Heaven's Door. I've never been a great standardized test taker. The LSAT was no different. I was accepted into several Detroit law schools. I was waitlisted at the University of Michigan. I had focused some attention on Boston, having met many Bostonians during undergraduate school at the University of Michigan. I was accepted at Boston College in Suffolk. I never tried Harvard. Then my Boston focus narrowed to Northeastern. Northeastern had set up a minority screening committee for low LSAT scorers. So, not an outright rejection, but I had to come in for an interview. With no money to fly or to stay at a hotel, my fiance and I drove all night to get to Boston from Detroit. And we arrived here a couple of hours before my interview. I remember changing clothes into a proper interview suit in one of the law school bathrooms. I remember some of the people that I interviewed with. Joseph Feaster was one of them. There were a couple of professors also. I believe Professor O'Toole was on the committee. I don't remember much of the interview itself. I do remember just trying to convince all of them not to define me by my LSAT score. And when the interview was over, Joe Feaster walked me out to the door, and I said to him, "Just let me in, and I will show you." He has since told me the stories that, the convincing that he had had to do to get me in here. My fiance and I drove immediately back to Detroit. But Joe was very successful in all of his urging and nudging, and I just thank him to this day for being a part of that committee. So, I was accepted, and I don't remember ever being in such an intimidating environment as law school. The language of the law was foreign to me. I felt so many of my classmates were far better prepared and acclimated than I was. There were 10 black students in my class. We shared a feeling of isolation, not aided by the fact that in its benevolence, Northeastern had set up a remedial torts class with Professor O'Toole. And it was an excellent, intimate class, but we were all thought of as the affirmative action students who were in need of special attention. My friends and study partners were the other minority students, 2 of them right there. Maybe not such a wise decision in retrospect, because it added to our sense of isolation. But we were in a place of comfort for one another. We did not all graduate. Some of us did not keep up academically. But I am forever grateful to my comrades in the long hours of studying and grilling and eating that we engaged in, and the sense of family that we developed. So, my third vignette is called Career Derailed. I took the bold step of applying to be a federal law clerk in my third year at Northeastern. I had done all of my co-ops in Detroit. I wanted to return there upon graduation. And as was true in 1976 and still true today, most black clerks are hired by black federal judges. Although I applied to most of the federal judges in the Eastern District of Michigan, I got one interview, and that was with a black judge. It was pleasant enough. In the end, he told me he was, and his word was, intrigued by my application and that Northeastern place. But he said he usually hired from Michigan or Harvard, his own alma mater. The favor he did do for me, however, was to call his son-in-law, who had a fairly young firm, which had recently been hired to do municipal bond work for the city of Detroit. His son-in-law agreed to interview me, and it would be the firm that I would work at from 1977 to 1983. It would be the firm where I would be its first black female attorney and its first female partner, and it would be the firm that would fire me. I never regarded myself as particularly pushy or aggressive, but as a so-called partner, I did believe that I was entitled to certain financial records and disclosures, particularly when the firm went into a financial tailspin and there were what I believed to be questionable spending decisions. I was not alone in my questions. A male who made parties at the same time that I did had and asked the same questions. I was fired for insubordination. He was not. And in a 1988 ABA Journal article, one of the named partners would say that, quote, Roberts was fired because of a very attitudinal sort of thing. This firm was prominent. It was upcoming. A collection of black men degreed from Harvard, Yale, and the University of Michigan, regarded as the premier minority-owned firm in the country. And they fired me. There have been 2 times in my career as a lawyer that I thought, maybe my career is over. And this was one of those times. This was the first time, and it was in 1983. I tried to get another job. I tried mightily to get someone to represent me in a sex discrimination lawsuit against the firm. And everyone was afraid. Everyone was connected. I finally did get someone to take my case, and I retreated to the legal department of a corporation in suburban Detroit. Now, fast forward 3 years. I've now landed a job at the United States Attorney's Office, and I have a lawsuit pending in federal court. And it's scheduled for trial about 2 weeks after I began my job as an AUSA. The morning of trial, the judge brought parties and lawyers into chambers. He turned to me and asked if I really knew what I was doing, if I really knew what I was doing to these good men. He ticked off the credentials of each of the named partners. Yeah, law clerk to federal judge A. Harvard, law clerk to federal judge B. University of Michigan, law clerk to federal judge C. And son-in-law of D. He then told me that if I didn't settle the case right at that moment, I would never practice law in his courtroom, so long as I was an assistant United States attorney. And sometimes you can't fight City Hall. And when the judge joined the defense team, I gave up that battle. Now, ironically, when I went on the bench in 1998, that judge was still there, 13 years later. And if he even remembered that he had crossed the line or used strong-arm tactics to beat me down, he never mentioned it, and nor did I. Vignette number 4. I call it Phoenix Rising. There were 2 times in my career when I thought it was over. The second was in July 1985. My father had one sibling, Shirley. She had Down syndrome, and she was profoundly retarded. She also suffered from deformities, and it was difficult to understand most things that she tried to say. Shirley lived in New Orleans with her mother, my grandmother, and folklore was that my dad had a great aunt who also had Down syndrome. Down syndrome was not the terminology that was used then. My Aunt Shirley was known as a mongoloid idiot, and we freely and unashamedly described her as such. She never went to school. She never developed any skills. The best that she could do was groom herself, and that sometimes took her hours every day. My grandmother never spent a day away from Shirley. Her constant prayer was that Shirley would die before her, because my grandmother said that no one could care for Shirley as she did. Well, her prayer was answered. Shirley died when she was 58. My grandmother was 80 and would die a handful of years later. So it was 58 years of 24/7 caregiving. We now know that Down syndrome is genetic, that it can be passed on, and that it can happen simply randomly as a mutation in the universe. As a child, I began thinking of what it would be like to have a child with Down syndrome. I became quite preoccupied with it. I thought of my grandmother and her decision, and I thought that I could never be as selfless as she was. As my older siblings approached marriage and family, I can remember urging them to get genetic screening and find out if they were carriers of the extra chromosome, and no one did it. My first child, Rachel, was born in 1979. I was a basket case in the early months of that pregnancy until amniocentesis was completed. We did it, and it showed that she carried no extra chromosome, and she was born on October 1, 1979, completely healthy. Shortly after that, I had a full genetic workup done. My husband and I had decided that if I was a carrier, we would not want to get pregnant again. We had decided we did not want to think about the possibility of an abortion, and we did not want to become my grandmother. So I had the screening done. I was not a carrier. We got pregnant in late 1984. My doctor told me that since I had had the genetic workup done, that I did not need to do amniocentesis. So, I was 34 years old when Jonathan was born on July 12, 1985, with Down syndrome. The shock of this was quite devastating to us and to our marriage. I could only think of my grandmother and Shirley, and I decided that I could not possibly work again. I can remember barely moving during that time. I tried to nurse Jonathan, but his muscle tone was so poor that he couldn't muster enough to suck. He lost weight. I stayed in bed for almost 3 months. My family helped me immensely. And late that fall, my sister-in-law called and told me to turn on the Today Show. They were interviewing a White House page about a day in the life of a White House page. And this young man was articulate in describing how he ran errands, delivered packages, talked to staff, and this White House page had Down syndrome. And that was the beginning of my rise from the ashes. I had not seen the world of possibilities for Jonathan. I saw only Shirley. Right after Jonathan was born, the hospital staff told us that we could just leave him at the hospital if we wanted to. They said that this is what most people did. We left the hospital with not one piece of literature, not one phone number, not one resource to help guide our lives, which now included this mentally retarded baby. The Today Show got me out of bed. We found a physical therapist and an occupational therapist. We found out that Jonathan had no peripheral vision. We got him glasses when he was 6 months old. He had eye surgery, he had ear surgery. We enrolled him in early intervention classes. He eventually was put into speech therapy. My daughter by then was 6 years old. She was precocious, she was brilliant, she was funny, she was athletic. Jonathan would not walk until he was 4 years old. or toilet until he was 5. We could not understand much of what he said. Yet I began to realize that it was not only my daughter who had great potential. Jonathan had tremendous potential as well. His achievements might be different, but they could be great. Today, Jonathan is 27 years old. He has a bevy of Special Olympic trophies for track and basketball and softball and soccer. He can read. He has a part-time job delivering mail for a business in downtown Detroit. He writes rap music and prayers. He speaks of going to college to learn how to break dance. He has a girlfriend. He has been a keynote speaker at several fundraising events and is a counselor in training in a program to provide social opportunities to people with mental handicaps. Jonathan is the happiest person that I know. He finds joy in all that he does and has been blessed with the ability to stay in the moment like no other person I know. And I have learned patience through him and perseverance through him. I did not become my grandmother, and my career did not come to a halt. In fact, right before Jonathan was born, I had been offered the position at the U.S. Attorney's Office, and I took it. So vignette number 5 is called Running with the Big Dogs. 4 months after my son's birth, I did take the job and began working as an AUSA. And I stayed there for 3 years. I handled a variety of cases in the civil division, including medical malpractice cases filed against the Veterans Administration hospital system. It would be in defending these cases that I met a partner at the Goodman Eden Millender Bedrosian Law Office who hired me to work at the firm to handle medical malpractice cases on the plaintiff's side. I worked at GEMB for 10 years, from 1988 to 1998. During my tenure there, I became its managing partner, the first woman and the first black to hold that position. I also had become active in several bar associations. I became president of the Wolverine Bar Association, a statewide organization of black attorneys. I became president of the State Bar of Michigan in 1996, which then had almost 32,000 members. I was the first and only black female to head the State Bar of Michigan. My bar work and reputation in the community as an attorney are what I would say were the primary ingredients in securing my appointment to the Eastern District of Michigan bench. I, however, didn't think I was good enough. But sometimes we have to look at ourselves through the prisms of other people to get the best perspective on ourselves. In the fall of 1996, there were 3 vacancies on our bench, but I was barely paying attention. I think in the back of my head, I thought, if I can't be hired as a law clerk to one of them, how could I ever become one of them? Judge Julian Cook, then the chief judge of the bench, had become a dear friend and a mentor. He was the first to call and ask if I was going to apply. I told him that I was busy managing my law practice, the State Bar of Michigan, and my 2 children, now as a single parent. Judge Cook was persistent. Over the few months before the application deadline closed, he called me to nudge me several times. He even had one of his law clerks bring me an application to my office. Another judge, Anna Dix-Taylor, who would become chief judge after Judge Cook, called and made similar inquiries. But I allowed their confidence in me to take a back seat to my own doubt. I called a 3rd judge to seek his advice, and he told me not to do it. He told me to wait my turn. He said that other black lawyers had applied and were applying again, and I shouldn't spoil it for them. He said too many in the game could spoil it for a black man, they were all men, who were more deserving, who had tried before. I still had time, he said. I was young. Quotas still, when you think about it, because no one thought our senator could possibly appoint more than one black person to fill these 3 vacancies. I let his negative voice talk me out of applying until the very last day that the application was due. And on that day, December 30, 1996, I was in my office with my then and now secretary, Linda Bertrice, who came and stood in my doorway. She had application in her hand, and she said, "We should do this." And we did. And to this day, I'm not sure how we were able to pull that application and all of its parts together by the 5 p.m. deadline. But we managed to get it done. And I do believe that God watches over us even when we have lost faith that he will do that. There were 90 applicants screened by a Citizens Merit Selection Committee established by Senator Carl Levin. Backers of another candidate spread lies and innuendo to derail my application. They failed. The committee interviewed the masses and recommended 10 people to Senator Levin. He interviewed the 10 of us, and he recommended 3 to President Clinton. And on July 31, 1997, President Clinton nominated me to the Eastern District of Michigan bench. This vignette I call "The Kindness of Strangers," easier than the aftermath. My nomination stalled for nearly a year. I was told by my state Republican senator that he could not submit my name to the Republican-controlled Senate Judiciary Committee for a hearing because of work that I had done in opposing the nomination of Robert Bork to the U.S. Supreme Court. He told me that many of the Judiciary Committee members were members of the committee during the Bork time, that there were bitter feelings, long memories, and he would not want to subject me to the embarrassment of not being voted out of committee. In the meantime, 2 other nominees, white males, had been sworn in and were wearing their robes and sitting on my bench. By then, too, my law firm had folded, and I was too close to the bench for any firm to hire me because no one wanted to be disqualified from practicing in front of me. So I became a solo practitioner. As I waited, I got a call out of the clear blue. This gentleman introduced himself as someone who had headed the Republican senator's own private vetting committee, and he wanted to meet with me. He told me that the senator wanted his own report on the 3 of us, so the committee conducted its own intelligence. He told me the committee had given me the highest marks, and he wanted to know why I had not had my hearing. I told him the Bork story, and he was incredulous. He then told me that he had raised a lot of money. He kept saying that I'd raised a lot of money for the Republican Party. And he was on his way to Washington, and he would speak to people, and he would see what he could do. My lunch with him was on Friday, April 24, 1998, and the following Tuesday I got a call that my Judiciary Committee hearing had been scheduled for May 14th. Money talks. Sometimes God puts his angels in our midst. Another example of help coming from the oddest places happened right after my hearing was scheduled. I called some of the judges I knew to tell them of the breakthrough. One had a very good relationship with Justice Clarence Thomas. My judge friend told me that he wanted to arrange for me to see Clarence Thomas when I went to Washington for my hearing. I did meet with Justice Thomas for almost an hour at the Supreme Court, and it was a relaxed, fun 60 minutes. He talked about his love of Motown music. He started ticking off the names of the Temptations and the Miracles and Martha and the Vandellas and clapping his hands. And he spoke of how difficult his own nomination process had been. About 20 minutes into the interview, he said that he had already met longer with me than President Bush had met with him before nominating him to the Supreme Court. He said to that day, he was not quite sure of why he was nominated, that he had few friends in the Senate, and that his nomination was nearly lost because he had no coattails to grab onto. He then said that the Republicans should not be surprised that President Clinton would nominate someone to the bench who would have opposed Robert Bork. He said that he had read all the information about me that had been sent to him and that he found me to be qualified. He then said, "If you can assure me that you could be fair, I'll go to bat for you." My hearing was the next day. In preparation for Senate Judiciary Committee hearings, the White House sends tons of information transcripts of past hearings, summaries. And it's almost like preparing for the bar exam because you have no idea what questions will be asked by the Judiciary Committee. So I have been preparing for this hearing for months. At the conclusion of the hearing, one of my former partners who attended it with me came up to me in utter disbelief. I remember him saying, this was like a love-in, not what I expected at all. The Judiciary Committee members, including Orrin Hatch and John Ashcroft, had thrown me complete softball questions. Counsel for the Republicans on the Judiciary Committee came up to me after the hearing and introduced himself, and he said, quote, "We heard from Justice Thomas, and you won't have any more trouble." On June 26, 1998, I received the unanimous advice and consent of the Senate. The President appointed me on June 29th, and I was sworn in on August 11, 1998, to one of the highest and most prestigious public offices in the country. I am so proud to be a part of the growing pluralism of the federal bench, because only a judiciary that is composed of members from numerous ethnic, religious, and cultural groups can adequately respond to the needs of a pluralistic society. And while pluralism on the bench does not guarantee fairness or effectiveness, it does help the perception and helps to build a court of legitimacy, one with different points of view, backgrounds, and experiences from which we all benefit, and one which in and of itself represents a significant achievement for social equality and the law. My final vignette is called Satisfaction Guarantee. My life as a federal judge has been most rewarding. I've handled significant cases, drug testing of welfare recipients, the constitutionality of the sex offender registry, public corruption, sedition, murder, free speech, a challenge to and the small, has brought its own cast of characters, all with the belief that their case is the most significant and all expect justice. This is my conclusion. One of my favorite poems in high school and college was Robert Frost's The Road Not Taken. It goes like this. Two roads diverged in a yellow wood, and sorry I could not travel both and be one traveler. Long I stood and looked down one as far as I could to where it bent in the undergrowth. Then took the other as just as fair, and having perhaps the better claim because it was grassy and wanted wear. Though as for that, the passing there had warned them really about the same. And both that morning equally lay, and leaves no step had trodden black. Oh, I marked the first for another day. Yet knowing how way leads on to way, I doubted if I should ever come back. I shall be telling this with a sigh, somewhere ages and ages hence. Two roads diverged in a wood, and I took the one less traveled by, and that has made all the difference. This poem is often misinterpreted. It's touted as one where the speaker chooses the road less traveled and is praised and revered for leading a courageous life. Yet if you pay close attention to the words, the writer is describing two paths equally worn, and he chooses one of the paths, promising to return someday to see where the other will lead. But the path he chose has its own forks, and he never returns to the path he marked for another day. Paths and forks and roads are often the metaphors for our life choices. This poem, with its equally traveled paths, means we have choices which we exercise, not knowing exactly where the path will lead us. The route and where we end up are not always in our control. We make choices, and more often than not, chance and timing join us on the journey. As the writer looks at the road in the beginning, he sees yellow woods, grassy knolls, fallen leaves, as far as he can, and then both paths bend out of sight. He tries to figure out what may be at the end of the path he chooses, but he can't. The end of the poem is so very poignant. I shall be telling this with a sigh. Somewhere ages and ages hence, two roads diverged in a wood, and I took the one less traveled by, and that has made all the difference. Is the sigh one of regret? Is it one of cover-up? Here the writer actually contemplates that he will tell a lie and rearrange the account of his life when it is examined to say he took the road less traveled as an explanation for the outcome of his life. Sometimes we just stand in the woods and we don't know which way to go. We can choose one path and wonder forever what we may have missed had we taken another route. The truth is, there's no right or wrong path. We have moments when we must make decisions, and we do the best we can. We have lives to live and worth living, worth choices, worth chances, without apologies, and it should be without regret or rearranging. My story is one of a route with twists and turns. Sometimes there were no signs at my intersections. Sometimes roads were closed and under construction. Others were marked hazard, travel at your own risk. Sometimes I had to go back to where I started and stay put for a while until I had fresh energy, supplies, and gas. Sometimes I had a companion and we traveled together for a while. And sometimes I needed a guide. Sometimes I walked in shadows, and sometimes I knew exactly where I was going. All of our lives are richly textured, to be lived without apologies. I hope the story of my choices, my decisions, my outcomes will simply let you know that there is no wrong or right path, just roads to take that may lead to a different place. In the conclusion of Walden, Henry David Thoreau wrote, I learned this, at least by my experiment, that if one advances confidently in the direction of his dreams and endeavors to live the life which he has imagined, he will be met with a success unexpected in common hours. Perhaps that's the best that we can hope to do, to move confidently in the direction of our dreams, because what is behind us and what may be yet ahead of us cannot begin to measure the value of the lives that we are all gifted to live, to make the most of, and to dream about. Thank you.
I made a right choice, right?
Any questions? Yes, Liz Rogers, my classmate too.
I'm also a classmate. Welcome back. I just wondered if you could talk a little bit about your experience here at Northeastern and how some of the remarks you made at our reunion were so touching and profound about the help that Northeastern gave and how some of the classmates didn't even know that.
Well, I mentioned a little bit about the remedial torts class that had been set up. I think we had another remedial. Did we have remedial property or something else? You don't remember? Maybe I think for me, you all. But once we got past sort of the stigma of that, I can tell you that there were white students who were very envious even that we had that special class. Professor O'Toole is probably long gone from here, but he was a wonderful, wonderful torts teacher. And we had a class that only had 9, 10 people in it, and it was just a perfect way to learn that subject matter. So I can remember being in it and not feeling so good about being in it, but it was probably the best way for me to learn towards. The screening committee that was set up, I think, was remarkable in its intuitiveness in figuring out, who was bigger and better than an LSAT score. Because some remarkable choices were made for minority students to be here. People have gone on and had illustrious careers because of that screening committee that was set up. And so, I just can't say enough about how very grateful I am that Northeastern took the extra steps that it did to, first of all, let us in, and then to keep us here, because not all law schools are doing that. Any other questions? Yes?
What's your federal career in terms of derailments, or, as a judge, and some of what you've done with regard to helping others in your current position?
One of the things that I did shortly after going on the bench, and this is a program that I've had in place for about 12 years now, it really disturbs me to look and see that it is primarily the black judges on my bench who have black law firms. And so one of the programs that I instituted, and which most of my colleagues have agreed to, is that we started a summer intern program where they allow me to accept applications and to do all of the screening and to place a minority student in their chambers. So, that's not an easy thing to do. If you know federal judges, we don't give up anything. And for them to concede for me to do that has been great. And out of that program, some students who have been placed through our program with some of the majority judges have been extended offers to be law clerks. And so I'm very, very happy about that. We've started a lot of other pipeline programs in Detroit, beginning at the middle school level to identify students who think that they want to be lawyers or judges, and we've assigned mentors to them, and just a few things. Yes, ma'am?
How about lawyers practicing in front of you? Are you seeing over the course of the time that you spent on the bench, are you seeing positive change as more women and minorities attorneys arguing in front of you, or is it still the old school practice? I'm just wondering what kind of changes you have seen.
I probably have seen more women coming into federal court to practice than minority lawyers. And that is a problem in the law firms, and we've been working with the law firms on that as well. So many of them they've hired people, they haven't been able to retain them. And federal court it's a different animal than state courts. It's certainly a different animal in Detroit. And so we have seen people come into federal court who really are not skilled enough to be there. And so what we have done also is through the Federal Bar Association, started a number of programs that would introduce people to federal court practice.